The Supreme Court just detonated a constitutional earthquake that buried gun shops beneath an avalanche. Inside, 72 hours display cases were vacuumed clean. If this is the first you are hearing it, you are already weeks behind the ground truth. The justices did not merely adjust firearm statutes, they dynamited the whole framework, throttling Second Amendment freedoms for almost 100 years. Today, I am unpacking the ruling that is redrafting concealed carry rules for millions who assumed their rights were dead forever. Hammer the subscribe icon and flip on notifications because the aftershocks you are about to see are still rattling every state house dome. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearm statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. The Judicial Quake, no Pollster predicted. You know how every courtroom attack on gun statutes for 9 decades has been flattened with the same bureaucratic reflex. We hold a compelling interest in public safety case dismissed. That playbook was just shredded. The court dropped New York State Rifle and Pistol Association v. Bruin, a decision that rewires how every single firearm limit in the country is judged. The constitutional yardstick it sets is so brutal that scholars instantly warned dozens of state codes cannot survive. Under this new exam, officials cannot merely waggle the public safety wand. They must demonstrate that the exact restriction aligns with America's historical tradition of arms regulation all the way back to 1791, when the Second Amendment was inked. No contemporary policy sermons, no balancing gymnastics, just frigid hard historical proof or the statute flat lines. Justice Clarence Thomas, writing for the 6-3 majority, formally tossed the two-step scrutiny routine courts had leaned on for generations. Within 48 hours, 14 separate federal complaints were launched aiming at everything from assault weapon bans to magazine caps. Each one swings Bruin like a constitutional wrecking ball built to pulverize those laws into powder. Yet here is the angle: almost nobody in the legacy press is spotlighting the slice that ignited a buying stampede so ferocious it left even 30-year industry vets slack-jawed. The spending tsunami that obliterated records. Store owners in New York, New Jersey, California, and Hawaii logged revenue figures that made Black Friday resemble a sleepy Tuesday morning. One Lone Star mega retailer rang up more concealed carry pistol sales in the 7 days after Bruin than it had in the entire prior quarter. 1 week equaled 3 months. The FBI's National Instant Criminal Background Check System logged 2.1 million checks in the first 10 sunrises, after the opinion an uptick of 340% over the same window the year before. This was not seasonal noise. It was not holiday hysteria. It was the legal terrain exploding in real time. Compact 9mm handguns ghosted off pegboard hooks so fast that Glock, Sig Sauer, and Smith & Wesson were hustling to crank overtime shifts. Dealers in Manhattan and Newark saw something they had never witnessed: lifelong residents who had surrendered hope of lawful carry strolling through the door, ready to reclaim a birthright their bureaucracy had buried for generations. But the jaw-dropper was not merely volume, it was who precisely was swiping credit cards. Denied applicants finally tasting justice. Here is the stat that will spin your head: 43 cents of every dollar spent on firearms in the immediate Bruin aftershock came from buyers who had once applied for carry licenses and been coldly rejected. That is point-of-sale data scraped across a dozen states. These were not panic purchasers, they were citizens told for decades they lacked proper cause to tote a sidearm for self-defense. Inside New York City alone, carry applications leapt from roughly 2,500 to north of 9,000 in 90 days. Bodega owners hauling cash cabbies, pulling graveyard shifts, women with paper stalkers and restraining orders, all systematically refused for years, suddenly heard the court announce that refusal regime unconstitutional. Firearms training academies saw enrollment rocket 340% in restrictive states. Women now compose 38% of fresh carry applicants, up from 22. The fastest growing cohort is 25 to 35-year-old city dwellers buying a first gun for protection. What fuels it is not red versus blue tribalism, it is the overnight realization that legal walls they assumed permanent just vaporized. Yet, while residents reclaimed freedoms, another legal wave was building, one still cascading through state codes like a slow-motion landslide. Today, the state-level litigation avalanche. At this moment, 37 active federal suits are swinging swinging Bruin like a battering ram against state gun codes. That tally was only 6-3 Mondays ago. Gun rights war chests stockpiled for years by outfits like the Second Amendment Foundation and Firearms Policy Coalition are now bankrolling synchronized offensives in the most hostile capitals. New York's hastily patched sensitive locations carry law met instant judicial destruction in Antoniuk Vivhokul. California's shrinking handgun roster is under siege in Reina Virv Bonta. New Jersey's Hollow Point ban. Maryland's modern sporting rifle prohibition. Illinois FOID card mandate, Hawaii's de facto carry ban. Each is being dismantled clause by clause. Attorneys copy-paste the court's exact phrasing into every brief, forcing lower judges to apply the history-only test. The battlefield now hands constitutional artillery to owners who can finally pulverize statutes unchallenged since the Wilson era. But there is a terrifying practical snag creating real danger for anyone trying to stay lawful. The compliance nightmare absolutely no one rehearsed. Picture yourself licensed in New York where Statute X bans carry in certain spots. A federal judge slaps an injunction declaring the ban void. You are legal there now, correct? Not even vaguely. Agencies discovered themselves trapped in a gray swamp where federal courts freeze state laws, yet those laws still sit on parchment awaiting appeal. You might lawfully carry under injunction on Monday, watch the stay drop Wednesday, and retroactively morph into a felon for Thursday's good faith stroll. Shops and instructors cannot issue firm guidance because the map morphs weekly. Some retailers hand customers printed disclaimers that basically read, "If this detonates, you are on your own." ATF and state AGs offer near zero real-time interpretation, leaving regular people to parse dense court PDFs with zero legal training. Street cops themselves do not know what they are allowed to enforce. Yet, amid that fog, one powerhouse lobby has gone eerily mute. Why the Gun Control Caucus hit radio silence. If you had tracked anti-gun groups pre-Bruin, you would have expected wall-to-wall cable tantrums after the ruling vows of emergency statutes. That outrage never arrived. Beyond antiseptic press releases, major outfits kept heads low. The calculus is simple. Under a history-only test, any knee-jerk replacement law would invite litigation. They would almost certainly drop, looking impotent. Worse, every courtroom loss cements bad precedent, hampering future plays. Behind closed doors, according to staffers in 3 state houses, strategy pivoted 180 degrees. Instead of fresh bans, cash is now funneled toward ivory tower historical digs, frantic hunts for 18th or 19th century analogs to modern rules. The telltale sign sits in recent legislation. Albany, Sacramento, Trenton, and Honolulu enacted revised carry codes that cite old sensitive places doctrines rather than flat denials, praying the paperwork passes the history exam. Groups quietly yanked backing from assault weapon bans, redirecting toward background check expansion and red flag statutes that might boast deeper historical roots. This is not surrender. It is tactical recalibration, and that breathing space gifted pro-rights lawyers priceless weeks to file challenges before the opposition finishes its homework. So here is the net. The Supreme Court reset has redrawn the American concealed carry map. Millions who assumed a sidearm was forever out of reach can suddenly exercise a freedom denied their grandparents. Gun counters were picked clean in days, and federal dockets are still popping like popcorn. Do you believe forcing governments to prove historical pedigree for gun rules is sound, or should contemporary safety fears carry more weight? Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.